Court decision really be overturned years later, putting millions in salary increases at risk for government officials? Discover how a simple letter from an insider led to a shocking reversal of a judgment that everyone thought was settled for good. This is the 91st case out of the 160 cases decided by Associate Justice Mario Lopez, chairperson of the 2024 Philippine bar examinations. Hit that subscribe button and get notified about our latest content. Watch our videos to increase your chances to recall these doctrines and concepts. This is the case entitled Development Bank of the Philippines vs. Commission on Audit. GR number 247787, March 2, 2021, facts of the case. In 2006, the Development Bank of the Philippines, DBP, granted substantial salary increases totaling 17,380,307.64 pesos only to 8 of its senior officers under a compensation plan approved back in 1999. The officers who benefited from these salary hikes were Reynaldo G. David, Edgardo F. Garcia, Rolando S. Geronimo, Jesus S. Guevara, Ma. Teresa L. Quirina, Armando O. Samia, Elizabeth P. Ong, and Benilda Tejada. However, this move caught the attention of the supervising auditor, who disallowed the salary increases on June 19, 2007, citing the lack of prior approval from the Office of the President, a requirement mandated by DBP's own compensation plan. Seeking relief, DBP appealed the disallowance to the COA's Corporate Government Sector Cluster A Financial. Unfortunately for DBP, on June 2, 2010, the COA cluster director upheld the disallowance, asserting that without the required presidential approval, the salary increases were unauthorized. Undeterred, DBP escalated the matter to the COA proper by filing a petition for review. On February 1, 2012, the COA granted DBP's petition, effectively lifting the disallowance. The COA justified its decision by citing a memorandum from former President Gloria Macapagal Arroyo, dated April 22, 2010, which retroactively approved DBP's compensation plan, thereby rendering the disallowance moot. DBP received a copy of this COA decision on February 6, 2012, and chose not to pursue further appeals, thus allowing the decision to become final and executory. However, things took a dramatic turn when, on March 27, 2012, Mario P. Pagaragan, DBP's vice president/officer in charge of the Program Evaluation Department, sent confidential letters to COA. In these letters, he requested the COA to reconsider its February 2012 decision. Pagaragan's argument hinged on the Omnibus Election Code, which prohibits salary increases within 45 days before a regular election. Since President Arroyo's approval was granted on April 22, 2010, just 18 days before the May 10, 2010 elections, he contended that the post facto approval was void. COA treated Pagaragan's letters as a motion for reconsideration. On April 13, 2015, invoking its authority under Section 52 of Presidential Decree No. 1445, the COA reversed its previous decision, reinstating the disallowance of the salary increases. This time, however, DBP fought back by filing a motion for reconsideration, arguing that the February 2012 decision had already become final and executory and that Pagaragan, not being a party to the original case, had no legal standing to request a reconsideration. On June 14, 2019, the COA partially granted DBP's motion for reconsideration. While it sustained the disallowance, it exempted the approving officers and recipients from liability on the basis of good faith, issue before the Supreme Court.
The primary issue that reached the Supreme Court was whether the COA could lawfully reopen and revise a final and executory decision based on new evidence purportedly discovered after the judgment had become final. Decision of the Supreme Court. The Supreme Court ruled in favor of DBP, holding that the COA had committed grave abuse of discretion by reopening and revising a final and executory decision. The court emphasized the immutability of final judgments, which dictates that once a decision becomes final and executory, it is immutable and cannot be altered, except under certain exceptional circumstances. None of these exceptions applied in this case. The court further noted that Pagaragan was neither a real party in interest nor an aggrieved party entitled to file a motion for reconsideration. Additionally, the Supreme Court pointed out that the COA unjustifiably delayed its actions, taking over 3 years to act on Pagaragan's letters and nearly 4 years to resolve DBP's motion for reconsideration. Such delays were found to be in violation of DBP's right to a speedy disposition of cases, as enshrined in the Constitution. As a result, the Supreme Court set aside the COA's decision dated April 13, 2015, and reinstated the COA's February 1, 2012 decision, which lifted the notice of disallowance.
What happens when a final judgment is no longer final? Do you think it's fair for a government agency like the COA to reopen a settled case, putting people's livelihoods in jeopardy? Share your thoughts in the comments, and don't forget to save this video to your favorites. Important doctrines. 1. Doctrine of immutability of final judgments. Once a judgment becomes final and executory, it is immutable and unalterable. This doctrine ensures that litigation comes to an end and prevents perpetual uncertainty in legal matters. 2. Legal standing in real party in interest. Only parties with a direct and substantial interest in the case, those who would be benefited or injured by the judgment, have the legal standing to file appeals or motions for reconsideration. 3. Right to speedy disposition of cases. The Constitution guarantees every person the right to a speedy disposition of their case before judicial, quasi-judicial, or administrative bodies. Unjustified delays in resolving cases can result in the violation of this right. If you found this legal analysis insightful, don't miss out on more content like this. Subscribe to our channel to stay informed and empowered by the law.